All right, picking up with the second portion of Chapter 5. I think Steve gave us a good insight into what it's like working for an administrative agency. We talked in Chapter 4 about where the power for administrative agencies comes from in the Constitution, and there's really not a lot there. So, we talked about maybe the 1930s being the time when administrative law sort of picked up steam in American history. And some of the cases we'll study focus on that, because I think in my study of the law, what I've seen is that you've got a sort of a steady increase of administrative law happening. And then the Great Depression hits and you have sort of a demand for it, and administrative law takes over. And now administrative law is in business law. One of the biggest things you're going to deal with is administrative agencies over, being the government and regulating your business. So Chapter 5 is going to sort of look at that, and then sort of look at what the limits of the government are. And, as someone who really is passionate about business law and the Constitution, I want you to keep that in mind, that there are limits to what the government can do. And, the framers of the Constitution wanted you to thrive as a business person. And that's what a lot of judges are going to see if you have to brave it in a lawsuit. So, all right, why have administrative agencies? That's the question posed in 5.1. And, what they describe is sort of the fourth branch of government, right? So we've got the legislative branch defined in Article 1 of the US Constitution. We've got the executive branch defined in Article 2, our president, and Article 3 is the judiciary. Where are all these administrative agencies? Where is the Department of Transportation? Where is the OSHA? Where's the Department of Health? All these things that, on a state level, you'll see too. They're not in the Constitution. So I think, those are ripe for challenging the power of those agencies. And that is a lot of what government is. But I think it's worth exploring what are the practical things that administrative agencies provide to citizens and to businesses, that we generally agree that there's a consensus that we need in our government. So one is that there's expertise. So, I thought it was important for Steve to tell you how he's primarily a scientist. He's not a government official, a politician, anything like that. And it's important that we don't have politicians running around giving, regulating business. I mean, the last thing you need is someone who doesn't know what they're talking about. Maybe they're a good politician, but they don't really know much about science. So we have expertise and continuity too. So politicians are elected, when it comes to people in Congress, that's every 2 years, or in the Assembly or in the Senate, it's, a little bit longer, but every 6 years. The executive branch is every 4 years when it comes to the president or the governor. And what you have is people who are isolated from those things. So that's the first advantage, is expertise and continuity. Second, what you've got is the Congress will delegate broad statutory guidance. Okay, so one of the elements of an administrative agency is to sort of, be in connection with the government still, with the politicians. So there's a balance there happening. And the third thing is clarity. So clarity is required when an administrative agency gets power. And from a lawyer's point of view, that's going to be where we might attack something. If my client, if their business is being regulated and it looks like the agency doesn't have power over it, that's going to be my point of attack. Okay, that's going to be one of them. And of course, we've got the right of due process that we talked about with the Constitution. So those are generally where I'm going to be focusing my issue spotting as a lawyer. All right, so why do we regulate the economy? And generally the answer is we want to fix the negative externalities. So things like the Great Depression or things like the COVID pandemic. Those are things where, you know, our citizens can run into a tailspin, our businesses can run into disaster. And you remember in chapter 1, one of the functions of the government, of the law, is to maintain the status quo. So, you know, if we run into negative externalities like a pandemic or a hurricane, the government gets power from the people. Generally, everyone gets together and agrees, hey, we want a stimulus package, or hey, we want to, you know, get this vaccine together, or things like that. So generally, when we run into negative externalities, is what the book calls it, or disasters, or just unexpected problems, we look to our government, we look to the law to help fix the problem. And, you know, that's been evolving as administrative law develops in history. You know, so we look at the free market economy, which is what we want in the United States. And actually having some regulation, you know, there's a balance there in maintaining a free market when destructive competition comes into place. So think monopolies, things like that. You've got maybe, you know, some bad actors coming in and disrupting the economy. So now we look at it from a different point of view. For the greater good, you know, we have these administrative agencies that might be able to oversee these also externalities, you know, negative externalities, things like that. So, and then we have undesirable or socially unacceptable business. So think of Martin Shkreli, we looked at in chapter 2, or chapter 3, no, chapter 2, when we talked about ethics. So, you know, the government comes in and they put him in front of Congress, and he had to answer about the pharmaceutical industry. You know, why are you jacking up all these prices? And sure enough, he was doing things that crossed over from ethics into criminal violations. So the first, talking about federal agency history, there's a list of federal agencies. It's figure 5.1, so it's jumping ahead a little bit into 5.2, but that's where you're going to find that. And in 1887, we had sort of the first national administrative agency, first federal, and that was the Interstate Commerce Commission, or ICC. And that was regulating trucking and railroads. So they're no longer around. They've developed into other different agencies. But then we had sort of an expansion in 1914 with the Federal Trade Commission. And then, you know, most of these federal administrative agencies in Table 5.1 developed as a result of the coming out of the Great Depression and the New Deal. And now we have more than 85 federal agencies. You know, that number is fluctuating a little bit, but you know, we've definitely evolved, and it's a big part of the federal government. It's also a big part of the state government, as you learned from Steve. And there's different types. You know, some are created by the executive branch and are overseen by the governor or the president if they're an executive branch. And then some are even developed by Congress, and some of them can be temporary too. So these are specialized bodies, and a lot of what they do is like licensing or giving permits and things like that. So, you know, those are hurdles that you got to jump through as a business person. So sometimes you need to consult with an attorney about how to get through it. And we'll go into that in a bit. But one term I want you to understand is bureaucracy. So when it comes to administrative law, we're talking about huge bureaucracies. And, you know, I asked Steve about, well, his boss is ultimately the governor, but he said it would take an incredible amount of time and experience to actually talk to the governor himself or herself someday. And everything in between is a bureaucracy. And that might seem frustrating if you're a business person to deal with all these different government workers. However, there's a reason for it. There should be a separation, some distance between the politicians and the professionals who work for the administrative agencies. All right, now getting into the sort of limits again and the legality of administrative agencies. The first case that's discussed in Chapter 1 is Schechter Poultry Corporation versus the United States. So you had a Supreme Court that was pretty active back then. Franklin Delano Roosevelt was our president. He's got 4 terms, longest serving president. In fact, after him, the Congress in the United States decided to amend the Constitution to say, hey, you get 2 terms as a president now. But he was so popular and so powerful that he's starting up these agencies. And then Schechter Poultry Corp is a case from 1935 where there's sort of a limit that the court finally says. And we're going to watch a video about that now.
In the 1930s, the steel industry was spread throughout several states. One business called Jones and Laughlin Steel Corporation, or Jones for short, was a sprawling company.
Hey guys, welcome to Hip Hughes History. Get ready for a quick one, baby. We're going to hit Schechter versus United States, 1935. You think Obama has problems? Wait till you find out what FDR had to go through. What a super duper court case to study, guys, if you're doing federalism, the 10th Amendment, or you're just doing New Deal stuff. But either way, it's a super duper court case. So FDR comes in 1933, right? He's got a series of programs called the New Deal, and he's whapping, trying to whap at the Great Depression. So one of these laws is the National Industrial Recovery Act. And Code 3 of this huge law passed by Congress gave the executive department, the president, the ability through executive action to enforce codes that were being written by private business groups, trade groups, to promote fair competition. And in this specific case, it's called Schechter Poultry Corporation versus the United States. There's a gang of poultry folk. And these poultry folk have written these codes. And some of the codes are like maximum hours you can work and some types of safety regulations, not selling sick chickens, and basically trying to keep everybody, to have kind of a fair competition kind of thing. So what happens? Well, Schechter Poultry's done a couple things wrong. They sold a couple sick chickens, and they're also violating the rules that required straight killing. Really quick, it's kind of funny. If you were a customer, according to this code or this rule being enforced by FDR, and you stuck your hand in the chicken coop, you couldn't pick the chicken you wanted to kill. You had to pick the first chicken that touched your hand. And I guess there was laughter in the court when they heard this. But basically, let's get to the decision now. So the question is, can Congress, through NERA, give the president the ability to enforce codes and regulations that are being passed by these trade groups? And secondary, does the Interstate Commerce Clause, because that's where the federal government's getting this power, give them the ability to regulate things like the way you kill a chicken, or can you sell a chicken to a guy with a hat? So let's giddy up and... All right, it's decision time. Now, this is a huge court case, not only because of the decision, but because of the reaction of FDR. So let's get to the decision. It's unanimous. No, void, ain't gonna happen. State power, 10th Amendment, devolution. For the first time, FDR's New Deal programs are getting struck down. And it's definitely kind of a line in the sand with the Supreme Court. First, they say, how dare you, separation of powers, be violated? How can Congress give the president basically the ability to kind of enforce codes that were passed by Congress? This is a violation of separation of powers by Congress giving the president their powers to basically develop or to take up legislation. And secondary, and this is the big one, is that they're going to shut them down on Interstate Commerce Clause. The Interstate Commerce Clause, this idea that, look at where Chester get his poultry. Well, he got it from Philadelphia and he's selling them in Brooklyn. So therefore, it's under interstate commerce. And look at my hand. And the federal government can regulate it. And what the court says is, no, you've just gone too far, because what Chester is doing by selling these chickens, he's engaging in intrastate. He's not doing interstate. Interstate can't go from the beginning all the way to the time you pluck the feather out on the butcher table. So basically what they're saying is this is a violation of 10th Amendment. These types of economic regulations aren't necessarily out of the box cray-cray, but if they're going to be done, they're going to be done by localities and by state, by the people that live there, not by the federal government. It's too much centralized government. So that's basically the decision. It's a shutdown. But what's the reaction? Stay tuned. Oh, FDR's really mad. Watch the video on court packing, all right? Because what FDR is going to do is he's going to propose that Congress write a new law that increases the number of justices on the Supreme Court, because that's not in the Constitution. They can do that. And then, of course, who picks the Supreme Court justices? Let me give this the think of. FDR would. And what this did is, this isn't going to happen. The public is going to react in a very strong way and say, no way, FDR, you ain't going to do that. But it's definitely going to spook the Supreme Court. And in a couple years, we're going to have a reverse in this kind of trend towards state power and devolution, when laws like the Wagner Act, collective bargaining and closed shops for unions, is going to be upheld by the Supreme Court. What are you talking about, Hughes? You talk too much. We hope you learned something about Chester Poultry Corporation versus the United States, something about the New Deal, something about the 10th Amendment, and something about the learning on the YouTubes. All right, guys, if you haven't checked out Hughes history, I don't even know how many more times I can ask without getting really disrespectful. So please. All right, there you go. Where attention goes, energy flows. We'll see you next time when we do the teaching on the YouTubes.
When school isn't a place you have to be, why not go to school where remote learning can be as remote as you want?
All right. Well, that was a very colorful lesson. I think a little bit more energetic than I could give you. But he touched on a lot of things that we've been talking about. And, primarily we're talking about the limits of administrative agencies at this point. And I want to talk to you about what it's like as a lawyer representing a business person now. So, you think of the plaintiffs in Schechter, maybe it's Chester, but I think when I learned it in law school, we said Schechter. But they basically stood up to the government. And there's another case at the end of the chapter that we're going to discuss where that happens. But primarily, we're talking administrative law, and we're talking about the way to appeal, the way to challenge an administrative agency. And actually, the bad news is that it's really hard. When you look back at my interview with Steve, I said, you're very powerful, Steve, when we deal with issues like eminent domain. The law is sort of stacked against us because it's basically like everyone against your personal property, or if it's a business, against your own business. And here's where the problem is. If you're a business person and an administrative agency is limiting your business, or if you're a property owner, they're trying to have eminent domain over your property. But, when I talked about civil cases, the burden of proof is just a little bit more on one side or the other. That's preponderance of the evidence. And when we talk about criminal law, burden of proof is very lopsided. It's very hard to convict someone in a criminal case as it should be, because you're going to take away their liberty. You're going to put them in jail perhaps, or limit what they can do with their life. And then when it comes to administrative law, only substantial evidence is required generally. So it's just enough evidence to substantiate what the government's doing. It may not even be preponderance of the evidence. So if you're a lawyer for someone, you may actually have preponderance of the evidence, but the administrative agency believes that there's substantial evidence to justify what the agency is doing. And so in these internal procedures, you're at a disadvantage. In 5.3, we're going to talk about the Administrative Procedure Act, and that's from 1946. That's where sort of the federal government is responding to this, cases like Schechter, where they're getting shot down, and they're saying, okay, we have to do something about these challenges to due process. So what they do is they establish the APA in 1946, and trial type hearings are required when administrative agencies have challenges. So basically, if an administrative agency gives you an order, you generally have a right to challenge it internally within the agency, and there should be some type of judicial review. And it's a fake judicial review. It's not in the judiciary system. It's within that agency. So when I get cases from clients who maybe get a citation from the DEC or the DOT, like Steve was talking about, or OSHA or the Department of Health, usually there's a built-in sort of due process fake court system built into the agency. And you have to exhaust your administrative remedies before you take the next step and go to the judiciary system. So, any lawyer is going to tell you, if you get a citation, you get a fine, you get a violation notice, you got to exhaust your administrative remedies. You got to follow the directions in that citation or in that fine or whatever. Usually there's some procedure outlined in there saying you got 30 days to do a challenge, an internal appeal. And you got to make sure you do that. You can't just call your lawyer and say, hey, I want to sue these bastards because they're fining me and I definitely didn't violate the law. Well, your lawyer is going to say, well, did you exhaust your administrative remedies? Because the next step is what lawyer in New York State, it would be what's called an Article 78 proceeding. So that's a remedy under New York state law that allows a lawyer on behalf of a citizen to sue a government official. Okay, so before you say, I'm going to sue the head of the Department of Health or the DMV, whatever the case may be, you got to exhaust your administrative remedies. And that means everything internally in the agency, you have to try to get them to reverse what they're trying to do before you sue them. But I've, in my experience, had to sue the government, had to sue an administrative official. I filed a few Article 78s in my experience. And many more times than that, I will say that I'm going to do that. And that's what it takes to get the government's attention, to get administrative agencies' attention, is a lawyer has to threaten that. But before we are able to do that, you have to exhaust your administrative remedies. You have to follow all the internal procedures of appeal within that administrative agency. All right, how do administrative rules happen? So we're still in 5.3, and the book covers the federal administrative agencies. And what happens there is the Federal Register is a process where there's notice to the general public. So if you are big into a particular industry, you're going to follow the Federal Register, and there's going to be notices in there by the administrative agencies who are going to give notice that a rule is being considered. Now, formal rules that are going to be up for approval, those actually have to have a public hearing, okay? So, or they can require a period of time for written submissions. So if you're in a particular industry and you're keeping an eye on it, you want to pay attention to any rules that are going to affect your business personally, and you want to let the government know about it if it's going to negatively affect your business, and you have an opportunity to do that. And that's a time when you can call in, well, you can call an attorney and see, what an attorney's opinion about it is. But a lot of times that's where attorneys will reach out to politicians because, if you have a chicken farm, for example, with Schechter, and it is going to hugely affect your business, you can call your congressman if it's a federal rule, and you can say, hey, I employ 150 of your constituents, and this is going to eliminate all those jobs. We're going to have an economic blight in your community if you allow this to pass as is. And that's a persuasive way to reach a politician. And a politician might have some sway over the administrative agency. So this is where, back to chapter 1, politics and the law can intersect, especially with administrative agencies who are on somewhat weak footing. They don't have a foundation in the Constitution. So they rely on politicians to, in a way, get their power. So that's one of the approaches that lawyers take when our clients are subject to administrative rules, either being created or evolving. All right, on to 5.4, we've got administrative burdens on business operations. So what you'll find is that these administrative agencies require you to fill out all kinds of paperwork. And that's when I talk about the bureaucracy, that's what we're dealing with. And, as a business person, you just want to do what you're good at. You want to make as much money as you can for the shareholders. But here we are with stakeholders. We've got the government, and they make you fill out all these forms, and you don't get reimbursed for them. Well, in the book, they talk about this administrative burden. And here's where we're back to the balance between, the government and regulation, and also our independence, our independent rights, and the social contract theory. So the idea is that the government creates these functions for us to thrive as a business. We have peace, we have the status quo, we have ensuring the rights of the minorities, we have independent rights, we have all those things, and that allows our corporations, our businesses, to thrive in society. So the downside to that is, because of all that regulation, we're going to have to fill out paperwork, and we're going to have to pay our taxes. So that's where you see the social contract theory working. And if you're a business person, you're not going to enjoy filling out all that stuff, but that's what we have to deal with. So, all right, the other topic in 5.4 has to do with inspections. So if you're running a business, these administrative agencies have broad authority that's been backed by precedent to enter especially well-regulated businesses. So depending on what kind of business you're in, you might have more of an expectation of privacy or more protection from government intrusion than others. So if you're running a restaurant, for example, you can expect in New York State that the Department of Health is going to come in and they're going to do some random inspections, and there's precedent that they're allowed to do that because it's a well-regulated industry in that respect. Another thing you could have is clandestine inspections. So the state liquor authority, for example, can come to your business, pretend to be a customer. They can be underage for purchasing adult beverages. And if you serve them, well, you're going to be in deep trouble. You're not going to be able to serve adult beverages, and that might be a big part of your business. But think about those two different things. If a health inspector comes in and says, hey, we want to swab underneath the stove in your kitchen, or we want to take some temperatures of the mustard in your refrigerator, that's a bit more intrusive than someone who's pretending to be a customer. But under case law, they're allowed to do that in well-regulated businesses. So that's sort of the balance that you got to keep in mind legally. All right, a case that comes up here, well, we'll covered at the end of the case, at the end of the chapter. So let's see. Here's where FOIL comes up, or the Freedom of Information Act from 1966. And the government was facing a lot of criticism in the 60s about being secret and not being transparent to the public. So there was a lot of public support for the Freedom of Information Act. And what that allows is the general public can request public records from the government. Now, there's certain exceptions under this law. You know, if there's maybe proprietary information, like a certain recipe or formula that's protected by a patent, you know, you're not going to be able to get that information from the government, even though the government has that information, because they have to balance protecting proprietary information of another business owner against you wanting that information. Or if there's an investigation going on of a business in a criminal nature, the government doesn't want to disclose that to someone else, to a third party, because it could jeopardize the investigation, the prosecution of something. But, or the safety and security of something. So I used to work in prisons, and I would ask for sort of information about the prison when it came to investigating police brutality or something like that. And they would say, well, we can't give you the blueprints of the prison because then, you know, your client might be able to figure out a way to escape. So something like that is justified, or the safety and security of a witness or something like that. So there's certain things that the government can hide information, but generally you can request public records from the government. And here's where that's important when it comes to administrative law. You know, if I'm representing a business and my client says the government's picking on me, you know, I'm just trying to do what everyone else is doing in my field of business, and the government's picking on me. Well, what I can do as a lawyer, what the business owner can do, is they can request information from the government and see if the government is being is picking on them, or if they're regulating the industry fairly. So that's where the Freedom of Information Act is relevant to administrative law. All right, I talked about the 5.5 covers the judicial review scope, but I've already covered that. You know, basically the concept there to understand is exhaustion of administrative remedies. So you want to make sure that before you think you can sue an administrative agency, your lawyer is going to make sure that you've appealed internally everything you could possibly do within the agency, because the courts don't want to deal with stuff that administrative agencies should still be dealing with. All right. When it comes to appealing a case like that, we've got the arbitrary and capricious standard. So again, it's already tough dealing at that initial lawsuit when you're suing a governmental agency. But on appeal, you have to prove, in order to reverse a lower court decision, you have to prove that, or you have to show the court that on the law, that the administrative agency is being arbitrary and capricious, which is a difficult test to prove. You know, you have to show that there's really no reasonable basis for what the government's doing in this case, and that it's completely arbitrary and capricious, which basically means it's on a whim. So it's a very hard standard to prove. But hey, when you have it, it can be an interesting case. So I'm going to pause here, and then we're going to go into the cases at the end of the chapter. Okay, so the cases at the end of chapter 5 include Marshall versus Barlow Incorporated. And that case involves, back in the 70s, you had the Occupational Safety and Health Act in 1970, which created the Occupational Safety and Health Agency, or OSHA, and they can go into businesses. They're supposed to regulate sort of the health and safety of employees in businesses that deal with sort of harmful exposure to chemicals and things like that. So if any of you have worked for, my first job was for a car wash. So when I was 16 years old and I got my working papers, I was like, I want to work at a car wash. I want to be that dude outside wiping down cars. And I had a lot of fun doing it. And that's who would come in. We heard a lot about OSHA would come in and maybe do an inspection or something like that. Well, in Marshall v. Barlow's, what happened was you had an installation company for electronics or electric and plumbing in Idaho. And OSHA comes in 1975. So they're a relatively new agency at that point. And they come in and say to the agent at the company is Bill Barlow. And, you know, I'm Kevin Kelly. So Bill Barlow, he's got an alliterative name like me. So I kind of like this guy already before I even knew about the case. But they come into the area of his business that's open to the public. And they say, hey, we want to do an inspection behind and see, you know, what you got going on back there. And Bill actually knows something about the Constitution. And he says, hold on a minute here, Mr. Government official, where's your warrant? And the OSHA official says, well, we don't have a warrant. You're just on our list for doing inspections. And, you know, a lot of business owners don't understand the Constitution or just think it's easier to get along with their day and let the government official in. But Bill says, no, you're not coming in here without a warrant. So the case, you know, ends up proceeding, and Mr. Barlow is actually ruled to be constitutionally correct. They can't just randomly enter his business. And what the court does is they differentiate from cases where there's, I talked about earlier, highly regulated industries. So for example, if you're serving alcohol at a restaurant, the state liquor authority is going to be able to, or the federal government's going to be able to, you know, regulate that. Here, though, there's no particular call or need for higher regulation. So this is a classic case of where the Fourth Amendment, which we'll get into in the next chapter, in chapter 6 dealing with criminal law, you know, that's where usually the Fourth Amendment comes into place against unreasonable search and seizure. But even as a business person, you know, you have a right, if you're just minding your own business and you're not from a highly regulated business and the government doesn't have a warrant, you know, they have to justify why they're going to come in and inspect your business. So this is a case where where the business owner was savvy enough to protect his business from a random inspection from the government. All right, the next case in the chapter, I think, is going to need some background. So I'm just going to play a video. It's not about the court case generally, but it is about what's going on at the time and the health concerns that are caused by this particular industry. So we're going to watch this little video and then we're going to talk about the case.
In South Carolina, the majority of the workforce, 200,000 people, work in cotton mills. In many Carolina towns, there's no other place to work. Life here has been dominated by the mills since the 1800s. Company towns, company houses, company-built schools and churches. The mills provided people with a living. In exchange, mill workers gave back a lifetime of hard work.
Our parents worked in the mill. We lived in a mill house, and each child got of age to go to work, if they didn't go to work in the mill too, they would fire the parents and make them move out of the house. And so therefore you just was almost compelled to go to work for the same company.
The looms of a cotton mill never stop. Each one demands a constant supply of thread. Always the pressure to keep up. The air is thick with humidity. The noise dulls the senses. But the real danger here could go unnoticed. Nearly invisible, millions of tiny fibers thicken the air. Years of breathing this cotton dust can leave you crippled with lung disease. Doctors call it byssinosis. The mill workers call it brown lung. Cotton dust attacks the tiny airways of the lungs, making it difficult for oxygen to get into the bloodstream. Eventually, the lungs constrict and become permanently damaged.
That dust in the cotton mill ruined me.
His lungs collapsed on him. They were just eat up with lint and dust, and so he's not worked in a cotton mill any since.
The doctor says there's no cure for brown lungs, what they've told me, that I would have to live with it the rest of my life.
Like the noise of the weave room, shortness of breath was taken for granted in the mills. Bad lungs forced many to an early retirement. Although the American textile industry first wrote about brown lung in a trade journal in 1940, and scientists described it as far back as 1705, mill workers were never told that cotton dust was the cause of their lung disease.
All right, so that video illustrates sort of the science behind the case that we're talking about here at the end of chapter 5. And this is American Textile Manufacturers Institute versus Donovan. And in that case, it's from 1981. And again, we're in the Supreme Court. And basically you had the cotton industry saying that the act established by Congress about how many, the measure is, let's see. Sorry, science is not my strong suit here. We've got 1,000 micrograms per cubic meter of air. So the science at the time says that if it's anything more than that, then you're going to end up with an unreasonable safety concern. You're going to have all these medical conditions when that happens, which means that the factories have to have ventilation in place and other measures to decrease how many of these particles are getting into their employees' lungs. So they can take, any measures that they want, whether it's ventilation or air masks or things like that, but they have to get under this level, or else it's going to be deemed under administrative law an illegal business to operate because it jeopardizes the safety and health of the employees. So there's that balance there. And, this industry was very powerful at the time, and they made it all the way to the Supreme Court. And the lawyers at least thought they had a chance. And what they were saying is that the language in the statute saying that there needs to be a cost-benefit analysis is the controlling standard for the court to review. And the court ruled against that. And they said that actually the scientific standard is the one that we're going to enforce. So you had the Supreme Court siding with the administrative agency saying, upholding this regulation and ruling against the business that said, hey, this is about the cost-benefit analysis. So there's always going to be a balance, okay? But these precedents, I think, are great ones to study because you have to think about what kind of business am I running? Does the government have a right to come in the case of of Bill Barlow? Can they come into my business and just come in without a warrant? Or am I the type of industry where my employees' health is at stake and they can enforce an administrative agency standard? So we'll talk about this the rest of the class when we get to contracts and things. There's also the idea we talked about earlier about the social contract theory. But administrative law, I can't stress enough, is something you're going to run into as a business owner or a business person that you may not have learned about in grade school or high school in civics, or that you could refer to in the Constitution. But these cases are excellent when it comes to, your rights in the Constitution, especially the Fourth Amendment right, when it comes to Barlow, and then due process and the evidentiary standard in court, in both cases, all the way to the Supreme Court. So we'll move on to Chapter 6 in criminal law, because there's some crossover when there's investigations and they carry over into criminal investigations, and we've talked about that a bit more and in chapters 1, 2, and 3, and we'll get into it more directly in Chapter 6. All right, see you then.